dirty cop gets unmasked and the prosecutor completely unravels.
Was there anything else that drew your attention to this vehicle?
The driver herself.
I think what this is akin to is bite mark evidence, which was outruled in the 70s and 80s.
This cop thought he could spew nonsense and get away with bending the truth. But evidence exposed every single crack in his story, and everything started falling apart fast.
The court overrules the state's motion to reconsider.
The arrest. On the night of January 22nd, 2025, Deputy Blake Fisher was parked along Highway 400 in Kansas during his evening patrol. Around 9:20 p.m., he noticed a Chevy Sonic driving eastbound at highway speed. According to the deputy, something immediately caught his attention. The car's windows appeared extremely dark. He later claimed he could not see inside the vehicle at all, even while watching it pass with his headlights shining toward traffic. Believing the tint violated Kansas law, he pulled that vehicle over.
Were you able to see into Miss Cowan's vehicle?
No.
Now,
I can't tell you what the interior looked like. It was too dark.
Behind the wheel was Kristy Cowan. What began as a stop for a suspected illegal window tint quickly escalated into something much bigger. Cowan was charged with driving under the influence, possessing a firearm while intoxicated, driving without an ignition interlock device, operating an uninsured vehicle, driving with a suspended license, transporting an open alcohol container, and unlawful window tint. However, when the case landed in court, the judge focused on a single critical question. Did Deputy Fisher actually have a reasonable suspicion to stop Cowan's vehicle? Court. The prosecution first called Deputy Blake Fisher to testify. Court attorney Jill Gillette asked him to explain why he stopped Kristy Cowan's vehicle that night. Fisher testified that as the car drove past him on Highway 400, he could not see inside because the windows appeared extremely dark. After pulling the vehicle over, he tested the tint and found it far below Kansas's legal limit.
what was the window tint reading of the vehicle when you were able to test it?
I'd have to refer to my report.
Okay.
It was 11% window tint.
What is the legal percent in the state of Kansas?
35%.
Gillette emphasized that officers often rely on training and experience in situations like this. Fisher explained that officers regularly judge window tint visually because there is no practical way to test it while a vehicle is moving. Then, defense attorney Jorge De Hoyos began cross-examination, and the tone of the hearing quickly changed.
You say that the technique you employed was you flash your high beams to see if you could see through the windows. Is that right? I mean, is this a lawfully approved technique? I mean, is there a sheriff's or a county association or any kind of police association that approves of this technique?
Not that I know of. I mean,
rather than focusing on what happened after the stop, De Hoyos focused entirely on what the deputy knew beforehand. He established that the observation happened at night on a dark highway while the vehicle traveled around 65 miles per hour. The deputy had only seconds to observe the car before making the stop. He relied on his instincts completely.
yes.
And have you become more experienced at using it on a daily basis?
Yes. So I had reasonable suspicion to believe that the window tint was too dark, so I initiated the traffic stop.
Deputy Fisher explained that officers simply relied on experience and observation. According to him, this was a common field practice.
Have you ever seen a study on the error rates of something like that, between the difference of being able to identify too dark and not too dark?
But the defense continued pressing him. De Hoyos asked whether lighting, reflections, nearby vehicles, or background colors could affect what an officer sees at night. The deputy admitted those conditions could potentially impact visibility.
Do you think that difference would allow you to understand negligible difference, like the difference between 33% and 37% dark?
If I took a class, it might.
Then came the turning point of the hearing. The defense introduced the dashcam footage from the patrol vehicle. As the courtroom watched the vehicle, it showed Cowan's car driving beside a large semi-truck at the exact moment Deputy Fisher claimed he noticed the illegal tint.
And do you agree that that's a little different than the testimony that there was another vehicle with it? There was another vehicle with it, right?
Yes.
This immediately created problems for the prosecution because the deputy had earlier suggested the vehicle was essentially by itself. The footage raised doubts about whether the surrounding conditions affected his perception.
Because I didn't expect the officer's testimony to be different from the facts shown in the video. Specifically, there were other vehicles on the road. There were vehicles in close proximity. I think what this is akin to is bite mark evidence, which was outruled in the 70s and 80s.
De Hoyos argued that the dark semi-truck behind the vehicle could have made the windows appear darker than they actually were. He claimed the deputy was making a split-second guess under difficult nighttime conditions rather than relying on objective facts. For the defense, this became the central issue of the case. However, throughout the hearing, Prosecutor Jill Gillette repeatedly pointed out that the tent ultimately tested illegal after the stop. She argued that officers only need reasonable suspicion, not certainty, to conduct a traffic stop.
He's asked you lots of questions about what was behind the vehicle, but you said you're concentrated on the front window and inside. Does it matter what's behind the vehicle?
No.
Your testimony was that you're focused on the window. Are you focused on being able to see what's in the vehicle versus behind the vehicle?
Yes.
Based on your experience, can you tell when a vehicle is approaching if it's faster or slower than what should be normally the speed of the vehicle?
Yes.
But Judge Charles Hart appeared focused on a different question entirely: whether the deputy had enough objective facts before the stop began. At one point, Gillette attempted to ask more questions about the tent meter reading obtained after the stop. De Hoyos immediately objected, arguing that what happened afterward was irrelevant because the legality of the stop depended entirely on what the deputy knew beforehand. Judge Hart agreed and sustained the objection.
So, to your knowledge, are there other deputies using the same practice of using the high beams to see into the vehicle to see window tint darkness?
I would assume so, yes.
Judge, I'm going to object to the relevance of these questions. If the strategy is inappropriate from the beginning, it doesn't matter if he does it 1,000 times a day.
Now,
Objection sustained.
Objection to relevance.
it's relevant if he confirmed that it was too dark.
By that time, we're saying it's already illegal, so it doesn't matter.
Objection sustained.
The judge emphasized a major Fourth Amendment principle. Police officers cannot justify a stop after the fact simply because evidence of wrongdoing is later discovered. Reasonable suspicion must already exist before the stop occurs. During closing arguments, Gillette defended the deputy's action by arguing that officers regularly rely on experience and quick judgment while patrolling highways. But De Hoyos argued that constitutional protections cannot depend on guesses or assumptions.
How can we tell the difference between window tint, just the circumstances of night, or if I'm holding something up? That's not illegal either. I mean, I guess my point here is that I want more than a hunch to pull people over.
He reminded the court that the deputy only observed the vehicle for seconds at night while it traveled beside another dark vehicle. There was no support for the technique and no objective measurement before the stop. Judge Hart ultimately sided with the defense.
Subsequently, the court finds the incident occurred well after sunset. There was no moonlight. There were no street lights.
The court noted several important factors. It was well after sunset. There was no moonlight, no streetlights, and other vehicles were present on the highway. Given those conditions, the judge concluded Deputy Fisher could not reliably determine whether the tent violated Kansas law before initiating the stop.
So this court determines that Deputy Fisher could not establish a reasonable inference or suspicion.
As a result, Judge Hart granted the motion to suppress. That ruling dealt a major blow to the prosecution because once the stop was ruled unconstitutional, every piece of evidence discovered afterward became inadmissible, including the DUI investigation, firearm possession, and all other evidence collected during the stop.
The defendant's motion to suppress.
The prosecutor immediately asked the judge to reconsider, arguing that the court was ignoring the deputy's experience and the fact that officers commonly use such methods in the field. But Judge Hart refused to reverse his decision.
Your Honor, the state asked the court to reconsider, ignoring You're ignoring the officer's training and experience that allows him, in the totality of the circumstances.
The court overrules the state's motion to reconsider.
The state later filed an appeal, and the case remains pending. What began as a simple traffic stop ultimately turned into a major constitutional debate. Nonetheless, it is a reminder that instinct alone is not enough in the court of law.